Hi, my name is Easton Lewis, and today I'll be going over Chapter 24, the Antitrust Laws. At the beginning of this chapter, it describes the antitrust law, and it describes trust as the business arrangement in which owners of stocks in several companies place their securities with trustees. Trustees are jointly manage the companies and pay out a specific share of their earnings to the security holders. The Sherman Act of 1890 aimed at regulating monopolies and is known as the Antitrust Statute. The goals of the antitrust statutes is the prevention of small businesses in an economy characterized by many sellers competing with one another. Prevention of concentration of political and economic power in the hands of few sellers in the industry. It also prevents the local government of business and protection against the effects of labor's dislocation. And lastly, a promotion of the maximization of consumer welfare using market principles and efficiency criteria. The exemptions of this is regulated industries, labor unions, administrative activities, agricultural activities, baseball activities falling within state action doctrine, cities, towns, and village activities, export activities, oil marketing, and lastly, the joint efforts by businesses to seek government action. The chapter goes on to describe the Sherman Act of 1890, Section 1. This is a combination, contract, or conspiracy. The act requires the presence of an agreement of collusion. The restraint of trade is also discussed, and that's the action that interferes with the economic law of supply and demand, the rule of reason standard, and the per se standard. The horizontal restraint of trade is also discussed in Chapter 24. And the restraint of trade that occurs between competitors at the same level of the marketing structure. It includes the horizontal price fixing, the horizontal division of markets, and the horizontal boycott. The vertical restraint of trade is the restraint that occurs between individuals or corporations at different levels of the marketing structure. The vertical price fixing is consists in this. The vertical territorial and consumer restraints is also included. And lastly, the tying arrangements and exclusive deal contracts is also included. Going along with this is the Sherman Act of 1890, Section 2. And this is to determine if a firm is attained monopolistic position, and the United States Supreme Court determines the relevant product and geographic markets of operation, whether the defendant has overwhelming power in the relevant markets, and if there is any intent on the part of the alleged monopolist to monopolize. Its relevant product and geographic markets is determined by courts using the concept of cross-elasticity of demand and substitutability. Factors that affect a company's market power includes market share, size of other firms, pricing structure, entry barriers, unique nature of industry, and the intent to monopolize, which is the attempts by alleged monopolist firms to exclude competitors or raise barriers to entry. It also attempts to monopolize, which is factors considered by the courts to change a firm. And these include the specific intent, predatory conduct, and dangerous probability of success. The chapter continues with the Clayton Act of 1914, and this prohibits price discrimination, tying exclusive dealing agreements, corporate mergers that sustainably lessen competition or tend to create a monopoly in interstate commerce, and interlocking direct dates. Section 2 and 3 is also listed in the chapter. And under Section 2, this injury to competition includes the following: primary line injury, second line injury, and territorial line injury. Section 3 is tying arrangements and exclusive dealing contracts. Section 7 is the mergers and adequations. And the reason for the increase in mergers is undervalued assets, diversification, tax credits for research and development, economic of scale, and the philosophy that bigness is not bad. The criteria for determining the legality of mergers include relevant product and geographic markets, and probable impact of merger on competition, and the relevant product and geographic markets. Lastly, the relevant product and geographic markets include the product market is determined by the substitutability of cross-elasticity of demand. Geographic market is also determined by where the merging companies compete. Section 7, the type of mergers include the horizontal merger, vertical merger, and conglomerate merger. The pre-merger notifications and remedies is also described in the chapter. And the pre-merger notification requirement is certain types of firms should notify the FTC and the Justice Department 30 days before finalizing a merger. It enables the agencies to investigate and challenge mergers that are found to be anti-competitive. The remedies is the civil injunctions, the cease and desist orders, and divestiture. Next in the chapter is the transnational reach of the U.S. antitrust statutes. Sections 1, 2 in the Sherman Act explicitly apply to the international commerce. The Antitrust Enforcement Assistance Act of 1994 provides authority to the Department of Justice to negotiate mutual assistance agreements with foreign antitrust enforcers. The Export Trading Companies Act extends the meaning of unfair methods of competition to practices in export trade. And lastly, the FTC and the Justice Department release guidelines that specify the basis of investigators. The limitations on the applications of the U.S. law overseas is also discussed, and the guidelines is set forth by the Department of Justice established that business practices should have sustainable and foreseeable effect on the U.S. commerce. The state-regulated models encourage price fixing and collaborations, which violates the U.S. law. As per the active state doctrine, the U.S. courts cannot judge acts of foreign sovereigns performed within their borders. And lastly, for the chapter is the enforcement of U.S. law overseas. And this is a court's decision commending certain business practices prohibited by the U.S. antitrust laws does not give an equitable relief to the plaintiff. The foreign defendant may be asked to pay triple damages if they possess foreign assets in the United States, and there is a treaty of friendship and commerce, the United States and the foreign nation providing for the implementation judicial decree of the U.S. courts and that nation's courts. So that's all I have for chapter 24. Learning of the different antitrust laws was very interesting, and how they are carried out was also interesting as well. Thanks.